I'm David Lombardo, and this is WCNY's The Capitol Press Room. In the waning hours of the legislative session, state lawmakers overwhelmingly signed off on legislation requiring the disclosure of generative AI by news organizations when utilized for their content. For more on this issue, we're joined by Sam Wheeler, Executive Director of the Writers Guild of America East. Thanks for making the time, Sam.
Thanks so much for having me.
Well, we can get into the logistics of this disclosure requirement in a second, but first, I want to talk about the rationale for this proposal because this is billed as being about public awareness, but based on the interested parties lobbying for this bill, it seems like the disclosure requirement is designed, at least in part, to discourage the use of generative AI to potentially preserve jobs. Is that ultimately your interest in this measure, or is there some other benefit that you see as primarily being the goal?
Yeah, that's a great question. I think that this is one of those times where, in advocating for our members who are journalists at, broadcast shops, at digital media publications, at a variety of different institutions, we can advocate both for journalism, and for the public. We think that this is a common sense disclosure provision that is that of course is going to protect journalists, but we also think that it protects the public. When we talk to our journalists members who overwhelmingly supported this legislation, the most common thing that we heard throughout those discussions was that they felt like they needed to do this to protect their readers, their viewers, and their listeners.
And the legislation would require a disclosure in those instances where generative AI was substantially used to create content. What does that threshold mean in practice to you? Because substantially seems a bit ambiguous.
That's a great question. So, if you look in the definition section of the provision, the same provision that talks about substantially composed by AI also makes reference to whether or not a piece of journalism is eligible for copyright. So, the US Copyright Office sets forth the standards for what is eligible for copyright, and they have consistently held for years and years and years that in order to be eligible for copyright, a piece of content, whether that be art or writing or journalism, has to have human authorship. Right. And so the Copyright Office has extensive guidance that's been upheld by courts who have considered the matter when applied to content generated solely by AI. And so basically, the threshold is that if a piece of journalism has enough human authorship that it would be able to be copyrighted, then it doesn't require a disclosure. If it is so wholly generated by AI that there is no human authorship, that it cannot be copyrighted, then it would not require that disclosure. So, importantly, this legislation really does not require disclosure for the vast, vast majority of journalistic output, even journalistic output that is created with the help of AI tools. Many of our members use AI tools, but they use those tools responsibly and ethically and in line with their, with the demands of their profession and the ethical requirements of their profession. This really just gets at pieces that are purporting to be journalism that are wholly generated by LLMs and other AI tools.
And that's been the argument from the bill sponsors here, who say this is
Mhm.
not about going after your local newspaper or your favorite cable television
Yeah.
station, that it is about those outlets that are basically generating AI slop. But in practice, is there any sort of safeguard that you think is particularly meaningful to ensure that those more mainstream outlets aren't picked up in the enforcement of something like this, that they don't fall under the scrutiny of the state attorney general who has enforcement powers here?
Well, I actually view this legislation as something that can protect mainstream outlets and can protect reputable, ethical journalists, right? Because as I'm sure you know, there's an ongoing conversation happening with and among journalists about what are our obligation, what are the obligations of journalists to the public, to readers, when it comes to disclosing AI, to using AI, what is the role for AI in a newsroom? And reputable mainstream outlets are putting together policies that govern this, many of which have policies that require disclosure to readers. And so we don't want those mainstream outlets to be at a disadvantage to less scrupulous outlets that are more than willing to just publish LLM generated content and pretend that it's coming from a journalist. right? Because part of what's animating this is that we do believe that readers and viewers, people who rely on news organizations to understand the world, to contextualize their place in the world, they want to be hearing from human beings, right? And they don't mind if human beings use AI tools for research, for note compilation, for, any number of ways that journalists legitimately use AI in their craft. But what they don't want is a computer program pretending to be a journalist with no way for them to know whether it was written by somebody who shares their physical reality, shares their experience, is a person, or whether it's, something that's generated by a computer program.
And that problem that you're highlighting is exacerbated by a real lack of media literacy that I think inhibits people from being able to discern just something as simple as an editorial versus a news story. But I'm curious how you think the enforcement will go with some of these less reputable sites that are just using AI. I mean, is there reason to think that they are going to comply with this, that they are concerned about enforcement, or do they just shut down and disappear once the Attorney General's office might start looking at them?
Well, we've seen instances of outlets purporting to be legitimate news organizations that are actually just a collection of AI agents or LLMs that when they get called on it, they shutter. Right? There was a story about out of Florida about a newspaper that it was revealed to be entirely AI. No human reporters, and that shut down as soon as they were called out. So. Um, it's a good question, right? I'm not a prosecutor. I don't work for the Attorney General, but what I hope is that this disincentivizes a particular business model that is predatory to the public, and that is kind of based, I think, on a wholesale misrepresentation to the public. I think that if people thought that they could publish AI generated content that is generated exclusively by AI, and that the public would be just as happy with that as they would be with journalism produced by human reporters, then they would do that and they would have no problem labeling it as such. But I think that the reason that people are opposed to this is because they know that people actually don't want that. So in terms of that, we are hoping that this legislation makes that kind of a business model where people set up kind of AI slop farms, that makes that a less viable business model in New York. And so people, instead invest in human journalism.
So when we talk about journalism, we're talking about a area of life that is constitutionally protected, and I'm curious how you think this navigates the freedom of our press as guaranteed in the First Amendment, and whether any sort of disclosure requirements represents sort of an undue or unconstitutional burden.
Yeah, so I think that's a great question, and I think that there are really two components to the question, right? The first is like, is this permissible under First Amendment law as we understand it in the United States? And I think the answer in that question is absolutely yes, right? This is fundamentally a disclosure requirement, and the Supreme Court has held since 1985 in a case called Zadurer, that factual and uncontroversial disclosure requirements are constitutional. This is good law. It's been applied by the Second Circuit, which of course is the federal circuit overseeing New York. And it's been applied to uphold laws that require disclosure of social media companies' moderation policies, of calorie counts in restaurants, of recently, the Southern District of New York applied this case to uphold the New York Algorithmic Pricing Disclosure Act. And so we think that this disclosure requirement falls pretty squarely in a line of First Amendment case law that says that factual disclosures is not compelled speech. But putting aside the actual legal, what does the case law say? We also just feel like this does not interfere with anybody's freedom of the press or freedom of expression. This is something, freedom of the press and freedom of expression is something that we at the Writers Guild take extremely seriously, particularly in 2026, with kind of constant attacks on journalists, but also on our members who write for film and television, right? We are in a time of a censorious and draconian government that is aimed at journalists a lot of the time. And so we take this really seriously. And so what I would point out to people who have concerns about this is that this law does not do anything to regulate the content of the news reports that go out. It does not say that you can't publish anything. It does not require you to publish anything. It does not even prohibit the use of AI tools, right? Journalists are still free to use an LLM, a large language model, to just produce, to wholly produce content as long as they put a label on it. So, from a how are we living in the world perspective, this doesn't mandate any particular content, it doesn't prohibit any particular content, and it doesn't even prohibit the use of the tools that we're trying to regulate. It just says that if you use them, you got to put a disclaimer on. And so, the same way that putting an explicit lyrics label on a CD didn't impact the First Amendment rights of the people who made that music. This doesn't impact the First Amendment rights of the journalists who might want to use these tools more aggressively than others.
Well, lastly, in terms of the disclosure requirement, what does that look like for the various types of content that news outlets might work in?
Yeah, I think there is like a level of discretion in the law that will allow people to, figure out what makes sense for their content. I mean, so for print journalism, right? It can be a pretty, I imagine it can be a pretty small text disclosure. It's obviously a little bit more challenging in audio and visual mediums, but this is something that I don't think should be a surprise or something that's beyond what these companies can handle, right? New York recently passed a similar law requiring disclosure when synthetic performers are used in advertisements, right? So the media industry is already thinking about how to do disclosures of AI use based on the first in the nation legislation that Governor Hochul signed last year, and so what that's going to look like, I think, is going to evolve. But I do think that those discussions are already underway based on New York's leadership on a similar issue.
Well, we've been speaking with Sam Wheeler. He's the executive director of the Writers Guild of America East. Sam, thanks so much for making the time. Really appreciate it.
Thank you.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.